Well, welcome everyone. My name is Carlos Soria Rodriguez, Ramon y Cajal Fellow at the University of Jaén, and it is my pleasure to introduce Professor Gemma Andreone. Professor Andreone is a renowned Italian international law scholar, currently serving as the acting director of the Institute for International Legal Studies, the ISGI, at the National Research Council of Italy, and she holds the position of research director in international law at ISGI and is an adjunct professor of international law of the sea at the University of Rome Unitelma Sapienza. She is a leading expert on international law of the sea, international environmental law, Mediterranean sea governance, and human rights. Professor Andreone has authored numerous books, articles, and papers on these subjects. Beyond academia, she has also served in advisory roles, including to the Italian government, and was a member of the Italian delegation to the United Nations negotiations on the BBNJ agreement, the Biodiversity Beyond National Jurisdiction Agreement. Today, she will be speaking on a very highly relevant topic, the impact of climate change on the oceans and marine resources. To briefly set the context, I would like to say some words. According to the scientific research, including assessments by the IPCC, Intergovernmental Panel on climate change is having a profound and far-reaching effects on the oceans and marine resources. It contributes to ocean warming, acidification, sea level rise, and declining oxygen levels. These changes severely disrupt marine ecosystems and endanger the biodiversity, among other issues. Coastal communities and economies that rely on marine resources are especially vulnerable, facing threats to food security, livelihoods, and critical infrastructure. In fact, climate change has a major impact on the ocean and the marine environment, but the relationship between climate change and marine protection is not always easy to understand or manage. It involves many challenges like scientific, legal, and political challenges. International law has tried to respond to these challenges in different ways over time. New agreements, such as the recently adopted PPJ agreement, legal cases such as the climate change advisory opinion before the International Tribunal for the Law of the Sea, or the involvement of the civil society, they all play a role in shaping how we protect the ocean in a changing climate. We will have the opportunity to address these and other important and timely topics. With that in mind, Professor Andreone, I'm very grateful to have you with us today. I'd like to begin with a few questions to help us explore how international law is addressing these issues, what progress has been made, and what challenges still lie ahead. So, my first question will be, what makes the relationship between climate change and the protection of the marine environment particularly complex? And the second will be, how has international law addressed this issue over time?
Thank you so much, Professor Soria, Carlos. I am first of all, I'm very pleased to be here and to discuss with you about this subject. And I also want to thank the University of Jaén because I think that this kind of format is very interesting and very connected with the changes that we are facing with currently. I want also to share my PowerPoint just to try to answer to your question better, and also just looking at your first question concerning complexity. Actually, really the relationship between climate change and the protection of marine environment is complex because it's bi-directional. So on one hand, climate change large caused by land-based human activities is severely affecting the oceans as well. So we are seeing rising sea levels, acidification, biodiversity loss, And on the other hand, we also have human activities at sea, so like deep sea mining or overfishing, shipping. So all those activities are contributing to climate change as well. So it is not only about mitigating land-based impacts, but also about regulating marine activities and restoring biodiversity or restoring the environment. So I also to come to your next question, that is how international law addressed this issue over time. I just want to give you a very quick overview about the evolution of states' obligation to protect and preserve marine environment, as it is mainly important to also to understand what is going on nowadays with the climate change litigation, for example. So the evolution of the obligation to protect the marine environment under international law has been complex and non-linear, as this timeline can appear. The evolution is actually can be traced back to the foundational trail smelter arbitration of 1941, which established the principle that states must prevent transboundary harm. So the so-called, nowadays so-called no harm principle. So in international law, the interdiction or the prohibition of transboundary harm is a customary legal principle nowadays, and it prohibits states from engaging in activities within their jurisdiction or control that can cause significant environmental damage or to other states or to areas beyond national jurisdiction. So this a major development came also in 1976, when an international law commission draft articles on state responsibility included the protection of the environment among the erga omnes obligations. These obligations were framed as duties owed to the international community as a whole. So, however, in the 2001 revision of this project, this reference was removed and the focus shifted to serious breach of peremptory norms of general international law without specific mention of environmental harm. Nonetheless, the idea of a general obligation persisted and took institutional form with Part 12 of the 1982 UNCLOS Convention, the 1982 Convention on the Law of the Sea, so-called the UNCLOS. That this chapter was entirely dedicated to the protection and preservation of marine environment, and in its article 192, we find a general obligation to protect and preserve marine environment, which seems to be in the idea of the drafters an erga omnes obligation. But actually, the other articles of this convention added value to this introduction of the no transboundary harm. For example, Article 235, that affirming responsibility and the liability of states for failing to fulfill their marine environmental obligations. Then we have had many other confirm about the existence of an obligation to protect and preserve marine environment, the environment in general, but applicable to the marine context as well. For example, the ISGI judgment of 2010, pulp mills case, where we find the general obligation of states to respect the environment of other states states or of areas beyond national jurisdiction. And this was very an important case because we find also the content of this obligation to protect the environment that can be also applied to marine context. So we have had several other legal milestones, as for example 2011 ICLOS Seabed Disputes Chamber Advisor Opinion that even clarified that sponsoring states bear legal responsibility for activities in the area and must exercise due diligence in line with the precautionary principle and best scientific knowledge. So we have had also the improvement of 3 implementing agreements. The third of them is the very renowned BBNJ agreement that has been adopted and open to signature in 2023. And this, as we will see maybe later, is a good step forward in protection of marine environment. But let's look now at the fact that we also have other 2 very important aspects that are the requests of states, of small island states to the ISGI for an advisory opinion on the obligations of states in respect of climate change that is still pending. And but we have had already the advisory opinion rendered by the ICLOS in May 2024, always on climate change, international law, and protection of marine environment. Let's just look very quickly at the content of this obligation to protect and preserve marine environment. That is an erga omnes obligation and falls on all states within the international community. And it is, as I said, interrelated to the customary prohibition to cause transboundary damages. So the content of this obligation mainly is the obligation are procedural, mainly procedural obligation that are arising from this general principle of no harm principle, that are for example, notifying the obligation of to notify to inform other states concerning environmental risks due to the activity of a state that can be transboundary. And the second procedural obligation is to cooperate in case of serious marine pollution. And then we also have other two aspects, content of this obligation that we have had in the evolution, and we get during the evolution of this obligation, that is conducting the obligation to conduct environmental impact assessment when we are in doing activities in areas beyond national jurisdiction, or doing activities in areas where we can cause transboundary harm. And the other content is also the obligation to apply a precautionary principle when scientific certainty is lacking. So actually, this is what we can say, and maybe we can recall that the no harm rule is a widely recognized principle of customary international law, and that in international law we already have had some attempt in the past, in tracing back to 2011, to get the connection between this obligation and climate change. So we maybe have to recall that small island developing states already asked the United Nations General Assembly to urgently seek an advisory opinion from the International Court of Justice in 2011, but this was not in a way accepted by General Assembly at that time because of the objection of a number of countries, of mainly Western countries, that were very worried about doing this link, no, that now we have, thanking to the new submission to the ISGI that was finally accepted, and now we are waiting for the decision on the advisory opinion of the ISGI.
So, in fact, what we have is this general obligation of protecting the environment in Article 192 that now it is developed by this ITLOS advisory opinion. But we also have the BBNJ agreement. You mentioned the BBNJ agreement. How do you think this is going to contribute to fight the effects of climate change? We have a different, in this instrument, we are dealing with the environmental impact assessment, but also the area-based management tools. How do you think it's going to contribute? And also we have to consider that the BBNJ agreement will apply to areas beyond national jurisdiction. How it's going to affect, and how is it going to be protected the environment within areas of national jurisdiction? How do we combine these both elements?
Yes, and I again share my screen to show you. Do you see it as a presentation?
Yes.
Yes, okay, thank you. Yes, first of all, let me say that as I was trying to show you in the timeline I presented, the BBNJ is one of the aspect and one of the instruments of the negotiations, very long negotiations that helped very much in strengthening the obligation to protect marine environment, but also to do this link with climate change, because actually negotiations were done on the basis of this fighting against climate change, and this was really maybe one of the main reason why delegations accepted the compromises and accepted to adopt a text by consensus that is a wide text that is dealing with many aspects you already anticipated, as for example environmental impact assessment that is regulated very in depth by the BBNJ agreement, but also establishing for the first time in the history of international law the possibility that an international convention is providing for the establishment of marine protected areas or area-based management tools in areas that are beyond national jurisdiction, so on the ICs. And this is the establishment of this legal regime, specifically legal regimes, is something very important if you want to straighten the fight to climate change, because you really have powers. The COP will have a number of powers to regulate activities, human activities on the high seas. So the BBNJ is a very complex agreement, and what is interesting to me is to understand that it is not only an implementing agreement of the 1982 Convention on the Law of the Sea, of the Constitution of the Oceans, but it's also a multilateral environmental agreement with all the characteristics, and so it's also an autonomous and innovative environmental agreement with a dedicated institutional structure, including COP with the regulatory powers, a secretariat, a scientific technical body, and a clearinghouse mechanism, capacity building, transfer of marine technology, and also committee and implementation and compliance committee. So all this will be regulated very soon. We know that we have had in April the first session of the PrepCom, so for establishing all the rules for the regulating the activity of this agreement and all the other organisms, and we will have another session in August. So this year is very important to assess all the legal instruments to make this agreement really important and for the fight against climate change.
So, in addition to that, what we can see is that there is a climatization of the ocean, that of the ocean agreements, that we can see how we can interpret the provisions of UNCLOS and also the BBNJ agreement in order to fight climate change. The ITLOS advisory opinion was talking about the marine pollution definition and how to integrate the climate change. Can you elaborate the significance of the ITLOS decision on the concept of marine pollution to integrate climate change?
Yes, I show you again a slide just to. Do you see it?
Not yet.
Not yet? Okay. Okay.
Now, yes.
Now? Yes, okay. Yes, in May 2024, the International Tribunal for the Law of the Sea delivered a landmark advisory opinion that addresses for the first time how states must act under the UNCLOS in relation to climate change. And the tribunal was asked two key questions. First, what specific obligation do states have to prevent, reduce, and control pollution of the marine environment caused by climate change? And second, what obligation do states have to protect and preserve a marine environment in light of those impacts? So the ITLOS, according to me, the ITLOS response was really clear and far-reaching, as it ruled that anthropogenic greenhouse gas emissions that are caused by human activities constitute a form of marine pollution under UNCLOS. So this is already something very important, because the idea of what is very much debated by doctrine, if we can consider climate change as part of the marine environment pollution and the form of marine pollution, and the ITLOS said yes, it can be considered. So that means that under Article 194 of the UNCLOS, a state have a legal duty to take all necessary measures to prevent and reduce even climate change, not only pollution of marine environment as we used to consider so far. So this isn't just about policy preference, but it's a binding legal obligation. So now, even more importantly, the tribunal emphasized that states must exercise what is known in international law as due diligence. So that means that this obligation of states is a due diligence obligation. So they need to take reasonable, proactive steps to prevent environmental harm, always based on the best available science. So this means that this includes also adopting climate mitigation strategies, regulating emissions, conducting environmental impact assessments, and cooperating with other states. There is also a definition of what is the due diligence that states have to comply with. The due diligence standard also considers that each state's specific capabilities, so its economic and technological resources, so the extent to which it contributes to the problem. So it's not a one size fits all approach, but it does require a serious good faith effort from every country. So I do think that this advisory opinion can be very useful for the development of and inclusion of climate change in the context of the protection of marine environment and conservation of marine resources as well.
Yeah, thank you. I see then that there is a clarification of the legal obligations that we have towards the protection of the environment. And I guess that this will also have an impact on the ocean legal framework, like the regional seas conventions, like the Barcelona Convention for the Mediterranean or the OSPAR, as well as with other multilateral environmental agreements like this Convention on Biological Diversity and the Paris Agreement as well. I guess that there we have a overlapping of obligations that will have to uh, aligned in order to function properly. I guess that will have an impact on them. So what we see with this case is that it's going to reinforce the protection. But uh, my question here is general and global problems like uh, uh, the global warming or ocean acidification, um, they will have to be taken care with all these instruments together. Do we need to make a relationship between them? Is it going to be complex to do that? What do you think about this?
Yes,
That
this
is
is
complicated.
mainly complex. I think that first of all, the concerning mainly the areas beyond the national jurisdiction, the role that can be the role of the BBNJ agreement can be really important and should be the COP of the BBNJ should be the place where even this fragmentation among legal systems that are competent, that have a mandate on the ICs. No, so for example, International Seabed Authority, but also regional organizations as OSPAR, for example, or even in the Mediterranean, the same, but the Mediterranean is quite just a bit different because we won't have the high seas anymore when all the national proclamation of the exclusive economic zone will be done. But actually, and anyway, the ICLOS advisory opinion is applicable to the Mediterranean Sea as well. But I want to distinguish between what the BBNJ agreement can do on the conventional level, that is to not only to create binding rules for state parties, but also to influence, policies, maritime and protection and prevention policies all over the world, so even in the Mediterranean. And on the other hand, we have the effects of the ICLOS advisory opinion, but also of the next ISGI advisory opinion concerning climate change, and also the effects of all the judicial practice that has recently been awarded by national jurisdiction and even other international jurisdiction concerning the responsibilities not only of states but also of companies, of other subjects, other actors of the international scene. So all this can contribute to the straightening of what I called the fight against climate change. And maybe this national practice, this climate change litigation phenomenon, can be really considered as contributing to the evolution of marine protection obligation. I think that could be a possibility. But and in this context, I find that, for example, the role of civil society or the role of non-state actors in general has been increasingly major and important, and is accelerating the transformation in the international community.
That was going to be my question. Yes, what is the role of the civil society in all of this? In all of this, there is a common understanding of what we are fighting, and what is the role in strengthening this climate change protection?
Yes. First of all, the civil society has had a big role in the rise of climate change litigation. So most of the cases are brought by NGOs or groups of concerned individuals, and they often rely on human rights standards as a legal basis. So they also did this link, very important link among the environmental protection and the human rights. What is interesting is that this movement is creating a sort of domino effect. So if one state is in Netherlands, for example, with the Urgenda decision, we had a very landmark decision that is condemning the government of Netherlands for not doing enough concerning the emission. So we have had several other countries where the same litigation were proposed, but this was thanking to the NGOs' work, and NGOs were also very active in the negotiations of the BBNJ agreement. So they are the non-state actors are explorating many different kind of participating to the international scene, to the decision making, international decision making. So it was very interesting to see how many, not only NGOs, but also representatives of industries or of companies were in the room at the BBNJ negotiations, and they were there to look into the eyes of delegations and saying we are here to control, to check which is the good and less good state concerning this fight against the climate change. So this was very, very interesting, and I think that the BBNJ was adopted thanking to this reputational issue, because even China decided not to be on the wrong side of the history, and to cooperate, to approve the
It's being
adoption.
essential, the role of civil society, and also we are in times where we have an opportunity to implement this BBNJ agreement and make the difference with
Yes.
all the elements that is incorporated, and also the interpretation that can provide these landmark decisions, as you said, the ICJ and the ITLOS. So let's see how it evolves. We are, I mean, there are many questions that we can continue talking, and it's quite interesting. I saw that the International Law Commission is dealing with the sea level rise. That is another problem that we have from the climate change. Uh, do you know how this is going to? What are the solutions they're going to provide? Or do you know how the UNCLOS can provide solutions to that? How it's going to be solved? What is it going to be? I know
This
it's a
is
difficult question, but
this is a very, very difficult question to
yeah.
answer to, actually, because there are even several aspects concerned.
Hmm.
So aspects that concerns the sovereignty expression, so sovereignty consequences on the life of small island states, for example, of the Pacific, that are so much interest and touched by this by sea level rise. So that is a very big issue, and cannot also be resolved and in the UNCLOS Convention, or by the UNCLOS Convention, because this convention has a very different scope, not dealing with sovereignty, but there are aspects concerning, for example, the baseline, for example, or the tracing baseline, or tracing the limitation lines, borders, of maritime zones that are regulated by the UNCLOS, and now are really facing with this issue of sea level rise. So I think the International Law Commission can give a very good contribution on this side, as well as on another aspect that is very important, and even with a lot of consequences, even in a sea as the Mediterranean Sea, for example. So a semi-closed sea, that is all the issue concerning the human rights that are enjoying by people affected, so by coastal communities, for example. So coastal communities now are the most affected by this issue, and not only because of the migration flux, for example, the increasing of migration flux, but also by because of the practical consequences of the sea level rise and all the effects of climate change. So we have already a number of suits from states as New York states, for example, or Rhode Island states against big oil companies because of the sea level rise effects, and in the United States, but we have several others all over the world. So that is really complex, and the contribution of the International Law Commission can be really important in clarifying human rights of affected communities, and also in putting the accent on one of the most simple maybe, but key, according to me, key factor, that is participation. So the participation of communities to the decisions is something that, for example, through the Aarhus Convention on the information and the obligation of states to give access to information concerning environmental aspects, this is something that should be always considered. So just through the democratic processes, we can try to find solutions. So, and I think that this can be highlighted and should be something that accepted by all states. It's now we are facing with something epochal, something that we have never seen before. So we need to straighten democratic process of decision making to try to find the solution.
Thank you. We see that this is a critical moment and a moment to take the opportunity that it's giving us to change things. And it's clear that the relationship between not just climate change and the protection of the environment is deeply complex, but not only these two areas, but also that is affecting human rights, statehood with sea level rise. So we are in a moment that we should make decisions as a society. And what you said, the public participation also through the Irish Convention, and also the coastal communities through UNCLOS and the BBNJ agreement. So we are covering a lot of ground here. It's a pity that we don't have much more time to continue. That brings us to the end of our conversation today. We have seen how international law how can gradually be adapted, how the BBNG agreement offers new opportunities, and how the civil society and the recent litigation is pushing the boundaries and raising more expectations. As the impacts of climate change intensify, we need to find institutional and legal responses, and that's what we were talking today and what you were exposing today. So thank you very much. There is much work to be done, but these kind of conversations are vital. So thank you again for being with us today. I really appreciate your time and insights, and also thank you to the audience for joining us. And I hope you found this discussion helpful, interesting, and thought-provoking. So thanks,
Thank
Professor
you to
Andreone.
you, Carlos. Thank you. Thank you to you.
Hope that
Bye.
we can continue in another venues talking
Thank
about this another important topics. Thanks very much.
Bye bye.